Our next case up for consideration is 250517, in the interest of A.J., and I believe we have Ms. Flanagan, who will be presenting arguments for the mother, and Mr. Martin will be arguing for the father. And so when you get set up and ready, just let us know, and we're ready for you.
Good afternoon. May it please the court. We're here because the juvenile court erred when it denied Ms. Caesar's request to terminate the parental rights of the father in this case. Specifically, inherent in the court's ruling were specific findings that clear and convincing evidence had been submitted to prove abandonment. The court found that Ms. Caesar was the parent and petitioning party under the code. The court found that the father had made 0 financial contributions to the child except those that he made while he lived with the child during the first 8 or 9 months of the child's life. The court found that the father failed to maintain substantial and meaningful contact with the child, as evidenced by the financial contributions not being made and also by not visiting the child at least monthly.
The juvenile court seemed to put a lot of credit to the father's testimony. What do we make of that? What should we do with that? Because he was testifying, I tried to send cards, I tried, all these different things. What do you make of that?
Your Honor, I understand that this court gives great deference to the lower court's credibility findings. However, in this case, the question has to be asked. If those things were true, why didn't he provide proof of those things?
Paper trail on the cards and things and letters that you sent from prison. You mail them out the door, they don't come back, and mom's saying, I never got them. What more could he have done to prove that than testify that he sent them?
Perhaps Your Honor kept a log of when he sent them. He couldn't identify any month or any date that he sent them. He didn't say, I sent a Christmas card or I sent the child a birthday card on her birthday on March 17th. Those would have been dates that presumably a parent would remember, right? Holidays. He didn't send anything for special holidays. He just said that he thought he sent a letter or two. Additionally, even if he had sent those letters, the fact...
Reverse the juvenile court's ruling in part based on the fact that this guy didn't keep a mailing log of when he sent stuff?
No, Your Honor. I want this court to reverse the juvenile court's ruling because the juvenile court found that he had abandoned this child by failing to make any financial contributions. And that is the first
piece of it, you think?
I think that and the best interests of the child
Comes afterwards, right? I mean, you have to have both the grounds and the best interest, but on the grounds themselves, is the lack of financial support your strongest angle, do you think, or not?
Not necessarily, Your Honor, because the code requires that the father maintain substantial and meaningful contact as evidenced by having monthly contact with the child. And even if he is prevented from doing so by the mother, which we do not concede he is still required to try to contact the mother. He could have tried to call her from the jail. And the fact that she had blocked his phone number would not have affected that because while he was in jail and was calling, those calls would have come through the jail number. That number was not blocked. There was no evidence of that. He didn't testify that...
to leave her alone, don't call me anymore?
After he continued to text her asking to invite her over for sexual encounters, insisting that she take custody of his older daughter when he went to prison so that the older daughter didn't go into the foster care system. He never asked her in those texts about his child with her. He never said, how is she? Can I talk to her? Can I see her? Does she need anything?
So the abandonment ground, there's basically two things that you have to prove, either that he didn't financially support to his ability or he didn't make the necessary contact. Do you agree that that's an or situation? So if you prove either one, you win the ground, right?
Correct, Your Honor.
Okay. So But that's different, is it not, than the financial ground? It's either subsection 4 or subsection 5, I think, where there's been a court order, and he hasn't met that obligation. There's no court order here, right?
Correct.
So that ground hasn't been alleged, that ground's not in play.
Correct.
All right. It's strictly to his ability as one of the pieces of the abandonment theory.
Correct.
Okay.
We didn't even plead that subsection. There was no court order for support.
With respect to what we often refer to as cash in contact, with respect to the cash, he was incarcerated for some period of time, but did he make any effort to pay anything once he was out of prison?
He didn't, Your Honor. So he was incarcerated first from December 23rd to December 28th of 2021. That's when he was first picked up on the charges. He was on parole, but he was picked up on those charges. He bonded out on December 28th of 2021, and then the contact text messages with Ms. Caesar started about January 4th of 2022. Those contacts were not about the child, as I've discussed. He did not offer to make any payment to her, nor did he provide any payment. He also didn't say, hey, sorry I was in jail during Christmas. I bet it was expensive. It was our daughter's first Christmas. Could I do something to help manage those costs? Nothing. Then when he went back to jail on February 14th, and I would implore the court, consider that those 6 weeks from December 28th of 2021 until February 14th of 2022, he had 6 weeks of precious opportunities that he could have shown up and asked to see his child. And he didn't. He didn't call. He didn't text. He didn't send letters or cards. He didn't ask family members to reach out. And he knew that members of his family had been in contact with Ms. Caesar because they wouldn't give him her phone number because they wanted to maintain contact with the child. But during those times, from February 4th,
First of all, I'm not sure I buy this theory because it's not in the code that somehow he has the obligation to go through her family members to get to her because she's blocked direct access. But secondly, when they won't give him her number, how does that help you in terms of his ability to contact her?
perhaps I misspoke, Your Honor. It's not her family. He knew that his own family members, his grandmother and either an aunt or a cousin, were having contact with Ms. Caesar and were seeing the child. His own family members.
The number, right? So again, how does that help you when it doesn't get him the access to her that you're complaining about?
He had plenty of other viable opportunities. He could have shown up at her house and knocked on the door. He could have filed a petition to establish custody, visitation, and support like he did in May of 2023 after he'd already been incarcerated since February of 2022. He was incarcerated that whole time from February 14th of 2022 until August 8th of 2023, and he waited until May 8th of 2023 to even fill out the forms to establish custody, visitation, and support. So during that time, he could have done lots of things. It's not like he had a lot of other things to be doing. He certainly could have written letters. He certainly could have sent drawings. He could have sent questions to my client asking about the child's status. He didn't do any of those things.
Counsel, can I jump to the best interest argument? Seems the district court order relied a lot about a relationship between the half-siblings, and there is an issue raised about access to the China file. Can you elaborate on that argument with respect to what information you needed out of that China file to help prosecute this 600A?
Well, I don't know what I don't know. So knowing that that China file existed because the father in this case was convicted of child endangerment for driving drunk with the older child, not my client's child, in the vehicle. Knowing what the permanency plan was in that case for purposes of reunification and whether the father had attended to his substance use disorder and done what he needed to do to be the father he needed to be to that child would have been a good indicator, as past performance is a good indicator of his future performance, as to whether or not we could rely upon him for doing what was in the best interest of this child. As it relates to the best interest analysis, The relationship with the half-sibling is important, certainly, but there's no indication that Ms. Caesar wouldn't have allowed that to continue to happen. As the evidence showed, Ms. Caesar was having contact with the father's extended family members. Additionally, that alone cannot be the reason that we delay permanency for this child. You know, this father, I'm told that this father got custody because he did what he needed to do in the China case, and the court clearly knew something that I wasn't allowed to view. So not granting it to me was one thing, then relying upon the facts in it was something else, Your Honor. Yes.
More time on rebuttal, thank you. Mr. Martin?
Thank you, Your Honor. May it please the court, counsel. I guess I'll start with the last issue first. In terms of access to the China file, I just don't see how that could be possibly relevant to the issue that was claimed in this case. The issue upon which the petition was filed was abandonment. Certainly the father's
Best interests?
it could go towards best interest, but the petitioner had to overcome the first burden in terms of the abandonment claim. And the court cited to the issues that she found relevant in her decision, that the father regained custody of the child, that there is a half-sibling out there, and that the siblings deserve to have a relationship. Anything beyond that, in terms of his parenting ability, wouldn't have any bearing on the issue of the abandonment claim at all.
Access to the China file, we don't know what the mother of the child was like, right? I mean, the court could have been picking between two parents that were maybe subpar, and he got custody without access to the China file to know what the mother was doing.
Yeah, I apologize, I don't quite understand the court's question.
Indicated that he has custody of the other child. We don't know what was going on with the mother in that file without access to the China file, correct?
Again, while I suppose that could have some bearing in this case on the father's parenting ability, in a small amount in terms of best interest, it has nothing to do with the abandonment claim. Again, simply the fact that he regained custody wasn't a danger to this child. That's information that the court was presented at the time of trial, that he had a residence, that he had employment, and that he was a suitable parent for this child.
One more question on best interest. Is it undisputed in the record that this child does not know who your client is?
That's correct. There's been no contact. On that point, hearing the petitioner's arguments, can't help but note in the court's opinion that she assigned blame significantly to the mother for that situation. It's clear that there had been, even if nominal, some attempts to make contact while my client was in jail, some attempts to contact while he was in prison. When he was unsuccessful, he filed his actions in the district court to establish the relationship. If petitioner had filed her petition for termination of parental rights in August of 2023, in September of 2023, right after he had filed that action, we might be in a completely different situation. But the fact remains that she did nothing. She sat on those actions for a period of almost 11 months. And then after he was out and started to make some progress with the court in terms of his request for paternity testing, it was then that she filed her action for termination.
Concede that under the abandonment ground, that all the mom has to prove is either failure to pay support within the other parent's means or lack of the contact?
It's an either or. Okay. She doesn't have to prove both.
You also concede that the record establishes that your client paid exactly 0 cents toward the child support since December of 21 when they kind of split up for good and kind of separated.
The support that he paid was nominal, if any. I think there was testimony that he had sent money at one point in time, although there was no record of that being sent either.
Then as far as the grounds go, not the best interest prong, but the grounds prong, how do you get around that problem?
The only amount that the court can assign for payment of support in a situation like this is $0. I think that's a reasonable amount of support.
Why would that be a reasonable amount of support?
Because
This child coming into the world, and his obligation is to contribute exactly nothing for several years. That's his obligation. You're good to go, bud.
I think that in terms of the burden to show by clear and convincing evidence that he did not provide reasonable support, the only amount the court can assign is $0, because there was no evidence that he had any substantial income to provide. There was no evidence that the child needed for anything, and he had taken action to establish a relationship with the daughter, establish a visitation schedule. I think in hindsight, it's perfectly reasonable for the court to assume that a child support order would have gone along with that at that point in time.
Like an argument that until he's ordered to do it, he doesn't have any obligation. Is that what you're arguing?
No, I think that my argument is that because the burden is upon the petitioner to show that there was a reasonable amount of support, and she failed to do that by not establishing that he had income or that the child had needs, that the court should assign an amount of $0 to a reasonable amount of support. It's very difficult in a situation like this to advise a client, this is the amount you should have paid. Guardianship case where my client, the mother, had not been actively participating in the child's life and had not sent any amount of support.
Record here, though, is that he did try.
He did.
According to his testimony, and so there must have been something there, right? Some amount of support or income that he could send, right?
I don't think there was any record as to what his financial ability to provide was.
To send something, so
Send some amount of money. I think my recollection is that his testimony was that he had sent $25 at some point in time.
somewhere, right? Like he had some kind of earnings, right?
I can only assume he had some amount of money in his account. Again, the burden rested on the petitioner to show what that amount could have been and what amount he should have provided.
$25 in 3 years.
I believe that was the testimony.
I just want to go back. You said that after he was released from jail, he was making progress with the court. Is that in the China file?
No, in the district court file. I believe it was May of 24, maybe sometime in early 24. I apologize, didn't review that ahead of time. He had, there was an order for the paternity testing to be done.
And I think I wrote down, you said he was doing well. Again, that evidence would be in the child need assistance file, or was there evidence, I didn't see it in the transcript here, as to what he was doing to better himself after release from jail?
Facts presented to the court that he was out of custody, that he was complying with the terms of his probation, that he was employed, that he had housing, and that he had his daughter in his care.
So he did testify he was at least employed when released from jail the last time and had an income?
Correct.
But had made no payments for support?
He had already filed again, I think the point being that he had filed his action to establish some relationship that is a natural derivative of that he would be ordered to pay some support, and that based on delays, based on the mother's failure to engage with him about that action, that there was never any support ordered.
Well, but again, that sounds like the theory that you told me you aren't following, which is until he's ordered to pay it, he doesn't have any obligation. Is that what you're saying?
When he's making the effort to establish that relationship, and there's a court proceeding pending, and the mother's not engaging with him, that the idea that he should know in advance that he's got to pay some reasonable amount of support in order to stave off the termination of his parental rights places an unfair burden on him. If he had sent $1, would that have been enough? If he had sent $5, $10, was he to know exactly what the court might have ordered in terms of child support?
talk about if he'd sent $5 or $10. I have a tough time understanding how you get any traction on that argument when the number is 0, and you've pitched to me that that should be the number. When he's employed, he has housing, he has another child in his care. He's apparently juggling all that through some financial means, but when it comes to supporting this kid, he's come up with exactly 0. I have a tough time understanding your argument of how that's justified. And as far as notice goes, the code puts him on notice, right? Because he has the obligation to pay a reasonable amount according to his means to stave off termination, right?
And I guess my point is that I think that the statute's problematic in terms of that ambiguous language, in terms of what's reasonable or not. We always have to look in hindsight and say, well, maybe that amount would have been reasonable, maybe that amount would not have been reasonable. We don't know.
I would entertain that argument if we were talking some dollar amount, but I have a tough time understanding how that argument works when the number we're talking about is 0.
Time is up, so finish with that if you have a response.
Again, I think that in terms of his action in an attempt to establish a relationship and establish what that support might have been, it's reasonable for him to rely on the court making a decision as to what that amount should be and not guessing in hindsight.
Thank you, Mr. Martin and Ms. Flanagan, for your arguments today and the excellent brief. Oh, no, you have your, I'm sorry. I am jumping way ahead on you. Sorry. You get your rebuttal. I know. I know. I'm sorry. You don't have to take a deep breath.
Thank you, Your Honor. As it relates to the question regarding the China file and the mother in that case, specifically in the China case, that's exactly the type of thing we needed to know. You know, in a China case, often a judge and a child in need of assistance is faced with 2 parents and has to choose the better of the not greatest. I mean, and we don't know that. And what we do know is that
What if,
my client was sufficient because when he was arrested in February of 2024, he asked the police to call my client to ask her to take custody of that child so that she didn't go into the foster care system. That kind of supports the thought that the mother in the China case wasn't an appropriate person to have the child to begin with if he's asking my client to take custody of that child.
authority for your client to get access to that China file? Because if I'm mom in that China file and the father of my child's other mom is trying to dig into my substance abuse records, mental health records, all the stuff that's very sensitive nature in a China file, I'm going to raise heck about that, right? Do you have some authority that would even give you the permission, to give the juvenile court permission to give your client access to that file?
I don't have any specific authority, Your Honor, no. What I would say is that when we're in a court that is a juvenile court, just as is the China court, a juvenile court, and we're considering the best interests of the child, there are lots of ways that the court could have protected that information, certainly making it only available to me and having me sign a protective order and not being allowed to share that with my client.
For that?
I don't have any.
Confidentiality provisions in Chapter 232.
I don't have any specific authority, Your Honor, just that I believe there are ways it could have been protected. Additionally, as it relates, Judge Greer, you asked about the credibility issue, and one of the things that I failed to mention when I first spoke was the father testified that he sent cash in an envelope from prison. That right there should question his credibility. There's no evidence that anyone in the correctional facility has access to cash. When they get booked in, the cash is taken away from them. And so the reason my client didn't receive it is because it wasn't sent, Your Honor.
Understanding that this child had a relationship, or at least access with the father's family, correct?
Maybe not the whole family, but at least 2 members. I believe the testimony was a grandmother and either an aunt or a cousin who had been communicating with my client and seeing the child, yes.
And were there any efforts by the father then to get this money or cards or anything if he wasn't getting success with the mother, through the grandmother to the child.
In fact, that would be an alternative means by which he could have attempted contact, right? He could have had his parents or family members drop off Christmas gifts or birthday gifts, something to show that there was a vested interest and not just a marginal effort. Additionally,
What provision are you relying on that allows the mother who has the child to block his access to her, and then he has the obligation to then go through his family members or her family members to try to third-party this stuff into her?
suggesting that anything gives the mother the right to block his access, but she didn't block his access. She simply blocked his phone number.
Use his family members to get to her, to get stuff to her, because he couldn't get it directly to her because she either claimed she never got it, or, and I don't know, I don't know if he sent it or not. I wasn't there, but if he did and she wasn't getting it, this idea that he then had the obligation to go, oh, well, let me find a third party that I can use as a courier to get this information to the woman that's blocking me from direct access to her. That I don't think the code says that.
Does say, though, is that he has a duty to maintain an interest and make meaningful contact.
Not blocked by the person that has care or custody of the child.
It is blocked. He's required to maintain communication with the person who has custody. Right? He could have sent letters. She blocked his phone number. When he was in prison, that phone, he wasn't using that phone. He could have called from prison and that would have rung through to her phone. She blocked his phone number after he continued to send her messages that were not related to the child. She didn't block his access.
Path here. My question is this using the third party conduit thing. That's what's irritating me, quite frankly. Okay.
In response to Judge
Judge Greer asked that question, but I'm asking you what authority there is that he would have that obligation if he was blocked, and I understand you disagree that he was blocked, but if he was blocked from direct contact with her, what obligation does he have to enlist his family members, her family members, or some other third party to get the stuff, whether it's money, cards, communication, whatever, to her?
I see that I'm running out of time. May I answer?
You to just finalize it quickly for us, thank you.
The statutory obligation, Your Honor, for all parents to figure out a way to take care of their children is what required him to do something. He was blocked, if at all, from that phone number because of his inability to focus on the needs of either of his children and instead ask for sex, ask to meet up, and ask my client to take custody of his child when he went to prison. He had plenty of opportunities to provide support and didn't do that, and the statute requires him to do so.
Ms. Flanagan and Mr. Martin, and thanks for the arguments today and the excellent briefing, and we will consider 25-0517 in the interest of AJ submitted, and my colleagues and I will get out a decision as soon as we can. Thank you.